Well, we just got an early Christmas present from Justice Amy Coney Barret. She is once again considering giving us an emergency injunction blocking Illinois' unconstitutional ban on so-called assault weapons. This literally just hit this morning, and the implications for this case and for gun rights are huge. But before I get into the details, please take a moment to like this video and subscribe to our channel for updates on this case. And please help us see this case home and help us overturn these gun bans once and for all by making a generous contribution to our legal war chest at the link in the description and the comments below. All right, so we have 7 lawsuits all across the United States attacking bans on so-called assault weapons. We filed in 5 separate federal circuits, and the goal was to get this issue to the Supreme Court as quickly as possible, and hopefully secure a nationwide precedent ending all semi-auto bans for good. And y'all, we are one step away from that right now. One of our cases is challenging Illinois' so-called assault weapons ban, along with a local AR-15 sale ban in the city of Naperville, also in Illinois. We asked the courts for a preliminary injunction that would block both the state and local gun bans from enforcement while the case was proceeding. And that was especially since our fellow plaintiff, Robert Beavis, is a gun store owner in Naperville, and his city and now state are literally trying to put him out of business. So now, a 3-judge panel of the 7th Circuit just ruled against us on this case. We've seen a lot of bad rulings from the federal courts this year, but this 7th Circuit ruling just might take the cake, because they ruled that AR-15s are not arms for the purposes of Second Amendment protection. Literally, these federal judges just said that America's most popular rifle is not a gun. It really doesn't get much more outrageous than that. But they were forced to turn to that nonsensical argument because it was the only way they could uphold Illinois' unconstitutional gun ban. Now that means, of course, that we are winning the argument. We just lost the ruling because that ruling was never about the arguments to begin with. The ruling was based on a hatred of the original intent of the Second Amendment. Now, when a case goes to the appellate courts, first it goes to a 3-judge panel. Once they rule, you have 2 options if you don't like that ruling. 1, you can ask for en banc review, which in this case would be turning to all 14 judges on the 7th Circuit and saying essentially, we think the 3-judge panel got it wrong, and we are requesting the entire 7th Circuit to knock down that panel ruling and rehear our case. So that's one option. Number 2, you can also appeal straight to the Supreme Court and hope that they take the case. Now what we ended up doing here is a hybrid approach. We asked for en banc review from the entire 7th Circuit, but in the meantime, we asked for an emergency injunction from the Supreme Court to suspend the Illinois and Naperville gun bans while that case is pending. Now, emergency appeals are usually referred to as the shadow docket by the left. And that's just a way of smearing the Supreme Court when they're putting a stop to leftist trampling of our rights. But here's how this part works. So every appellate circuit is assigned to a Supreme Court justice to screen and answer these emergency appeals and requests. For the 7th Circuit, these go to Justice Amy Coney Barret. She has the ability, all by herself, to say yes and issue us that emergency injunction blocking the enforcement of the Illinois and Naperville gun bans. She can do that. Or she could say no, in which case we could appeal to any judge on the Supreme Court, including Justice Thomas. Now the third option is she could send our request to the entire Supreme Court and basically have everyone vote on whether or not to grant us our emergency relief. She hasn't done any of these things yet, but this morning, 3 days after we filed our emergency appeal, she demanded a response from Illinois. In other words, before deciding anything, she turned to the gun grabbers in Illinois and Naperville and said, now give me your best arguments for why I shouldn't block these gun bans here and now. Y'all, that's huge. That means we're in the door, and that is usually the hardest part. Most emergency appeals never get the slightest consideration, and this is a very encouraging sign. Now, if this sounds familiar to you, it's because this is actually the 2nd time we've gotten here with this case and with Justice Barret. If you've been following our case at all, you may recall earlier this year, after the district court judge ruled against us, we asked the Supreme Court for an emergency stay while we appealed to the Seventh Circuit. Once again, Justice Barret demanded a response from Illinois, signaling that she was considering giving it to us. Now that sent the Seventh Circuit into a tizzy. So they took the very unusual step of putting us on what our lawyer called the rocket docket. That means they scheduled our oral arguments for much sooner than we would normally get. Now, as it turns out, Justice Barret did submit our case to the entire Supreme Court, but they decided to let the Seventh Circuit process play out before stepping in. That's pretty much on brand for how the Supreme Court has handled most gun cases following Bruen. They keep a close eye on them, but they try to let the lower court process play out before stepping in, as long as the lower courts don't take too long. So, we had our oral arguments at the Seventh Circuit, and months later, they finally ruled against us. And as I said earlier, it was an outrageous ruling, and it was absolutely not consistent with the Supreme Court's Bruen and Heller precedents. The Seventh Circuit said that AR-15s aren't guns entitled to Second Amendment protection. Now, I want to point out that the Supreme Court has already considered the question of what an arm is in the context of the Second Amendment. And here is what they said in their 2008 Heller ruling. Quote, "Some have made the argument, bordering on the frivolous, that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communications, and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding." That is literally what the Supreme Court has said. The Second Amendment covers all bearable arms, full stop. Can you bear an AR-15? Absolutely. So it's covered by the Second Amendment. Now, Heller also said that you cannot outright ban weapons that are in common use, that are commonly owned for lawful purposes like self-defense. But the Seventh Circuit said that was essentially bad logic, which is a very bold thing for a lower court to say about a Supreme Court ruling. The Seventh Circuit also said that an arm can be banned if a judge thinks it's, quote, particularly dangerous, whatever that means. That would allow a judge to ban any gun, because if it's the judge's discretion, they can decide all guns are particularly dangerous. Seventh Circuit also said that guns can be banned merely because they're similar to weapons formerly used by the military. Now that's a whole lot of nonsense, and that's putting it nicely. But more importantly, it's an outright defiance of the Supreme Court, because Bruen said that you cannot balance the so-called public interest of the gun control law against the Bill of Rights guarantee. Not only did the Seventh Circuit panel resort to interest balancing anyway, but they accused the Supreme Court of not actually striking down interest balancing to begin with. When we submitted our emergency appeal just a few days ago, we pointed all these things out to the Supreme Court and we asked them to step in. And the fact that, once again, it's not an immediate no, and Justice Barret is actually considering it, is huge. It means that she also recognizes that the Seventh Circuit justified multiple Supreme Court rulings, and that is not okay. She's given Illinois until December the 6th to give their rebuttal, and then we wait to see what she does. Now, this might feel a little bit like Lucy holding the football. It feels sometimes like they're giving us hope initially, only to say no afterwards. Now, we are hopeful that that's not the case this time, since the Seventh Circuit has actually ruled. And there's no requirement that the entire Seventh Circuit give us that en banc review. But we will wait, and we will see. And if the Supreme Court says no again, we'll fight round 2 before all 14 judges at the Seventh Circuit. And if they rule against us again, we will officially appeal on the merits to the entire Supreme Court. No emergency appeal this time. So we will keep you posted on that. But I would ask you in the meantime to please consider a generous contribution to our legal war chest. The bills for these lawsuits to overturn semi-auto bans are piling up, and we need your help to see this battle home to ultimate victory. Thank you so much for your support, and we are keeping our fingers crossed for, hopefully, more good news soon from the Supreme Court.